Hi, everybody. Just before we quickly jump into this document, it was a question actually I had for Dr. Ed Johnston, and he explained that in the UK we have a slightly different system. So having posed the question to Michael Cicchini, who is simply not simply, but is a trial lawyer, doesn't do appeals, and he's purely a trial lawyer. And obviously a great writer. I was very pleased that he wrote back to me and sent me this article that he wrote, and gave a lot of other explanation as well, which we'll get to once we've had a look through the article. So let's share screen, and let's go over here, click on that, and move me out the way. The top there. So this is in 2018 for the Oklahoma Law Review. And how much does this ring true with Ken Kratz? Combating prosecutorial misconduct in closing arguments. Michael D. Cicchini. Oops, let me change that to a thing like, there we go, that's better. Finally, we get to the opening bit. Prosecutorial misconduct in closing arguments is rampant. Prosecutors make improper arguments because it is a highly effective, yet virtually risk-free strategy. That is, even if the defense lawyer quickly identifies and objects to the misconduct, the jury has already heard the improper argument, the available remedies are toothless, and the offending prosecutor rarely suffers any consequences. This article proposes an alternative approach for combating this problem. Rather than waiting to object until after the prosecutor makes the improper argument, defense counsel should consider a more aggressive strategy. The pretrial motion in limine. This motion seeks a pretrial order to prevent the misconduct before it occurs, and in cases where the prosecutor violates the order, it establishes a framework for addressing the misconduct in a meaningful way. This preemptive strategy has several advantages over the conventional reactionary approach. First, even if the motion in limine fails to deter the misconduct, it alerts the trial judge to the improper arguments before the prosecutor makes them. Second, it preserves the issue for meaningful trial court review outside of the jury's presence without defense counsel having to raise difficult and risky objections in the middle of closing arguments. Third, the motion in limine approach also provides a framework for developing meaningful remedies for the misconduct. These include providing the opportunity to draft thoughtful and effective curative instructions and affording time for client consultation before requesting the more serious remedy of a mistrial. And fourth, in the event a mistrial is declared, the motion in limine approach may even protect the defendant from re-prosecution. See what we've got. Okay, when a prosecutor makes improper closing arguments to a jury, he or she violates the defendant's due process and other constitutional rights. Yet, despite the prosecutor's supposed role as Minister of Justice, rampant prosecutorial misconduct in closing arguments still exists. Anecdotal reports, appellate court decisions, and even published studies demonstrate that such misconduct has become the norm rather than the exception. Prosecutors abuse the closing argument process for two primary reasons. First, they know that improper arguments are highly effective, stirring jurors' emotions and inviting them to convict for reasons other than proof beyond a reasonable doubt. Second, and equally important, prosecutors have learned that this form of misconduct is virtually risk-free. The difficulty defense lawyers face in quickly identifying and immediately responding to the improper arguments typically results in the prosecutor's misconduct going unchecked and the state gaining an illegal advantage without repercussion. Moreover, even when the defense lawyer is able to quickly identify and object to the misconduct, doing so may cause more harm than good. Further, the available remedies are often ineffective. Worse yet, the conventional reactionary approach to improper argument only encourages this form of prosecutorial misconduct. This article, therefore, proposes a more aggressive strategy for combating and possibly even deterring prosecutorial misconduct in closing arguments. The pretrial motion in limine. Part 1 discusses the importance of closing arguments and the widespread nature of prosecutorial misconduct in this phase of the criminal trial. Part 2 takes the first step in combating this form of misconduct by helping the defense lawyer identify and understand many common forms of improper argument. Part 3 examines the numerous problems with the conventional after-the-fact approach to dealing with prosecutorial misconduct, including the risks associated with objecting in the middle of closing arguments and the general ineffectiveness of the available remedies when an objection is sustained. Part 4 of this article then outlines the alternative approach to combating this form of prosecutorial misconduct. Instead of waiting for the improper argument and then objecting after the jury hears it, defense counsel should anticipate and preempt the misconduct via a pretrial motion in limine. This motion in limine approach educates the trial judge about the various forms of improper argument, seeks a pretrial order prohibiting these arguments before the prosecutor can make them, and protects the defendant in the event the prosecutor violates the court's order. If granted, the pretrial motion in limine relieves defense counsel from having to raise risky mid-argument objections to the misconduct, yet still preserves the issue for trial and appellate court review. The motion in limine also establishes a framework for developing meaningful remedies for the prosecutors in unethical behavior. It provides defense counsel and the trial judge the opportunity to craft effective curative instructions and affords defense counsel sufficient time to consult with the defendant before requesting the serious remedy of a mistrial. Further, in the event the court grants a mistrial request, the motion in limine approach may even protect the defendant from a retrial. Appendix A provides a sample motion in limine, and Appendix B provides sample curative instructions tailored to specific types of improper arguments. Such instructions can, in some cases, provide an adequate remedy for the prosecutor's misconduct. Closing arguments to the jury. Closing arguments are often viewed as the most important part of the trial, providing the attorneys with their last opportunity to convince the jury of the defendant's guilt or innocence. More specifically, the closing argument allows the attorneys to sum up the evidence within a narrative framework to help the jury understand and interpret the evidence. This includes arguing about the reasonable inferences to be drawn from the evidence, the credibility and demeanor of witnesses, and the credibility of evidence generally. The attorneys may also help the jury understand the issues by applying the evidence to the law. In the rebuttal portion of the closing argument, the prosecutor may respond to arguments of defense counsel. With regard to criminal prosecutions, courts have stated that the prosecutor occupies a semi-judicial position, and the rules of professional conduct have grandly ordained the prosecutor as minister of justice. Consequently, a prosecutor's duty, above being an advocate for the state, is to ensure that a defendant is afforded a fair trial. Yet, despite these grand titles and lofty standards, prosecutorial misconduct is rampant in closing argument, its variety limited only by the prosecutor's imagination and boldness. In many cases, improper prosecutorial arguments violate a defendant's due process rights and, depending on the particular argument, other constitutional rights. A prosecutor often commits this form of misconduct because by the end of the jury trial, he or she may have become so devoted to winning the case that his or her emotions intrude and result in a win at all costs closing arguments not based on the facts brought out during trial. One explanation for this behavior is that confirmation bias leads prosecutors to be overconfident in their conclusions about the guilt of particular defendants. This process is often set in motion when the prosecutor's office first receives a referral from law enforcement and, despite having limited information, concludes that the suspect is guilty. Then, throughout the case, the prosecutor focuses on information that confirms this pre-existing determination of guilt while discounting or even ignoring, and should we add, and even hiding information that contradicts it. Regardless of the underlying explanation, prosecutorial misconduct in closing argument can be incredibly harmful. Although argument does not constitute evidence and the jury is instructed not to consider it as such, the use of dramatic, compelling, or even inflammatory argument reflects a perception that argument is a valuable ingredient of the deliberative process, and scientific evidence supports this perception. Empirical research on the regency effect suggests that people tend to remember best and be influenced by the latest event in a sequence more than by earlier events. Because jurors enter deliberations without closing arguments, especially the prosecutor's rebuttal, still ringing in their ears, those words could have more impact than the actual evidence presented much earlier in the case. Although other research demonstrates that some jurors will have made up their minds by the time closing arguments begin, such findings do not minimize the harmful effects of the prosecutor's misconduct, even though some jurors may have already decided the defendant's guilt. The prosecutor's closing argument provides ammunition for them to use in the jury room so that they can become an extension of the advocate. Further, prosecutorial misconduct may be as frequent as it is harmful. As far back as 1987, for example, one judge conceded that prosecutorial misconduct in closing argument is chronicled with alarming regularity. Nonetheless, he maintained that the majority of prosecutors desire to see that justice is done rather than to add another conviction to their record. But attributing the misconduct to only a few bad apples was probably a naive claim, even in 1987. Today, any criminal defense lawyer who adopts such a trusting approach does so at his or her client's peril. I like the fact he got that in. In my own experience, the majority of prosecutors routinely make improper arguments to the jury. Indeed, prosecutorial misconduct in closing arguments seems to be the rule rather than the exception. Moreover, some forms of improper argument are deployed with such frequency and by so many different prosecutors that there is reason to speculate that such arguments may be a part of the prosecutor's training, and much of the empirical evidence on the pervasiveness of such misconduct supports this anecdotal evidence. Therefore, the well-prepared criminal defense lawyer must enter each jury trial expecting the prosecutor to strike foul blows. The reason for this miserable state of affairs is twofold. First, prosecutors know they are likely to get away with this form of misbehavior, as misconduct in jury argument proves to be one of the most difficult problems to address for criminal defense counsel. This is because defense lawyers are unable to recognize many forms of improper argument, and even when they do, the misconduct typically happens too quickly to mount a thoughtful and effective response. And second, appellate courts have proven to be highly tolerant of this form of prosecutorial misconduct. For example, in Briggs versus the state, the defendant's appellate lawyer argued that the Florida Court of Appeals had repeatedly warned prosecutors that a particular type of argument was unethical and constituted misconduct. As such, the lawyer asked the court to make good on its 7 previous warnings to prosecutors and order a new trial, one where the defendant, Briggs, could be tried free of improper argument. The court's response to the lawyer's request was the same as its response in the previous 7 cases cited by the appellate lawyer. If the improper argument continues, the appellate courts will be compelled, as appellant's counsel argues, to fashion a special remedy and reverse convictions so obtained to provide an effective means of deterring further misconduct. Despite this further admonishment, however, the court again failed to act in a meaningful way to protect Briggs and other future defendants from prosecutorial misconduct. Prosecutors do not fear such tired judicial mantras, though, as evidenced the court's own admission that for over 30 years such prosecutorial tactics have been disapproved of, yet they continue to occur in the absence of meaningful action to prevent such misconduct. Prosecutors have accurately interpreted the court's 8 warnings as yet another idle threat in a very long line of idle threats. A California appellate court dealt with prosecutorial misconduct by using similar empty warnings. After repeated incidents of misconduct by the same prosecutor in several cases, the court bemoaned, "It is disheartening, to say the least, to learn that the prosecutor takes pride in our admonitions, apparently because we did not reverse the judgment rendered. We most earnestly urge counsel to reconsider her approach, lest in the future it becomes necessary for us to reverse otherwise sustainable convictions." The problem for California defendants, however, is the same as that faced by Florida defendants. The future never comes. For many decades, other courts throughout the country have dealt similarly with the problem of prosecutorial misconduct, using myriad warnings to prosecutors to stop making improper closing arguments. However, as in Florida and California, these judicial threats are nearly always empty and free of consequence for the offending prosecutors. While most appellate judges timidly ask prosecutors to abide by the rules of ethics and trial procedure, one judge has recognized that this attitude of helpless piety is, I think, undesirable. Such an attitude is indeed undesirable for 3 reasons. First, it demonstrates that appellate courts are unable to control the prosecutorial monster they have helped create, thus exposing the court's ineffectiveness, or, at bare minimum, unwillingness to put an end to the conduct. Second, and more significantly, such helpless piety does nothing for the defendants who were victimized by the prosecutor's misconduct. And third, it certainly does nothing to prevent the victimization of future defendants. Given the current state of affairs, what, if anything, can criminal defense lawyers do at the trial court level to protect their clients? Rather than waiting until closing statements to react to improper arguments made by the prosecutor, defense lawyers should take preemptive measures in order to effectively battle this form of misconduct, one that all too often has come to be expected. So that's the first 10 pages of this 56-page article. I think we'll hold it there and tackle this in bite sizes. Obviously, we all watched Ken Kratz, some of the ridiculous things that he said in closing argument. It's always been something that's annoyed me. Remember how he referred to A23 as being a bloody handprint of Stephen Avery. And Jerry was like, hold on a sec, have I made a mistake? Have I missed something after this year and a half? Have I missed something? Have I done something wrong? No, it was just Ken Kratz trying to claim that what he knew perfectly well wasn't Steve's bloody handprint was. That's the type of prosecutorial misconduct that I think is quite damaging. And I think it needs this to be stamped out. This would be a great step to begin with, would be to curb some of the enthusiasm of the prosecutors to go for this win at all costs. To hell with the rules. I'm just going to do what the hell I like to win this case. Anyway, hope you found that first bit interesting. As I say, it's great that we've got people like Michael Cicchini that's I'm able to send an email to, and within a couple of days he'll send me something fantastic like that particular document of his. And I think it's great that these documents are looked at. It's just further information for us, so that when we're talking till they're walking, we really know what we're talking about. And not just sort of anecdotal stuff. We can point to specifics and say, this is a problem. This is a problem of prosecutors. They need to be, shall we say, a leash put on them by the judge as to what they can and can't say, particularly in closing arguments. Anyway, we'll catch you all soon. Bye for now.